Ready, start. Further submitted that the appellants did not tamper evidence or influence witnesses, did not abscond, and did not violate any other bail condition while on bail. As such, setting aside of the orders granting bail was uncalled for and without justifiable reasons. He further submitted that the application for cancellation of bail preferred by the state before the High Court was not maintainable. Since an earlier application for cancellation had already been rejected by the sessions judge, the proper remedy of the state was to approach the High Court under sections 401 and 482 CRPC rather than by way of a fresh application for cancellation before the High Court. Lastly, as the state did not challenge the order of the sessions judge refusing to cancel the bail, the said order has attained finality and is now unassailable. The state filed a status report pursuant to an order of this court. Upon perusal of the report, apart from the antecedents of the accused, it is seen that the accused were identified based on CCTV footage of the crime which was recovered from a nearby house. Relying thereon, learned senior counsel Mr. Dinesh, representing the state, urged that the impugned order suffers from no infirmity and thus deserves to be upheld. Opposing the petitions, Mr. R. Basant, learned senior counsel, appearing on behalf of the respondent number 2, within bracket widow of the victim, bracket close, submitted that the Sessions Court failed to consider the severity of the allegations against the appellants and granted bail by a non-speaking order. On the other hand, the order impugned in these appeals is well reasoned, and this court ought to be loath to interfere therewith. Out of the total 10 accused, the High Court set aside the orders granting bail of only 5 accused after considering all relevant factors, distinguishing them from the conspirators. The appellants herein were classified in the category of the actual assailants in the gruesome murder. Specific overt acts attributable to each accused were discussed in detail by the High Court. Our attention was also drawn to the several criminal antecedents of the appellants. A-2, along with a co-accused, allegedly committed offences even after the grant of interim protection by this court on 30th July 2025. Moreover, it was submitted that the Sessions Court granted bail to the several accused upon hearing only the public prosecutor and not the special public prosecutor who was appointed for the case. Lastly, the High Court rightly held that delay in filing an application for revocation of bail is no ground for rejecting such an application. Mr. Chakrabarti responded by stating that Vishnu entered into the district as he was required to attend the ongoing trial of the case on that date. As regards the commission of an offence by Vishnu, it was submitted that the purported victim had denied the involvement of the accused persons in the offence by way of an affidavit filed before the High Court, in proceedings instituted by Vishnu under Section 482 CRPC.